Were you appointed
Miss
when I
Coley?
missed the last meeting?
Yeah.
If you can head this way, your nameplate's over there, but there's not a computer there, so I'm gonna have you sit over here. Miss Lane is not gonna be here today.
I don't know if I should wait a minute for Nancy.
She told me she was gonna be here.
I'll wait 2 more minutes.
But you can wait a few minutes if you like.
Okay.
Sir. Miss Grace, if you want to start at 3:05.
Okay.
And just before you start, just do this. The camera will pick up, and then they'll
Gotcha.
magic.
Cool. I feel like I have the world at my fingertips.
Not quite, but at least in this area.
It's 3:05. I'm going to call this meeting of the Nuisance Abatement Board to order. First item on the agenda is the approval of the minutes from the March 4th Nuisance Abatement Board meeting, March 4th, 2020, that is.
Board Member Gary Baker, I move that we approve the minutes of the March 4, 2020 Nuisance Abatement Board meeting as submitted in written summation by the city clerk.
Do we have a second?
Second.
Okay. The motion is seconded. All in favor, say aye.
Aye.
No nays. That was unanimous. So the minutes have been approved. Agenda item number 2 is citizens to be heard regarding items not on the agenda. Do we have anyone who would like to be heard? Seeing none, we'll move on to new business items. Item number 1 is to elect the chair and vice chair. So I can't participate in this part since I'm the chair.
For the board members who were newly appointed, Ms. Grayson has been serving as the chair, but according to your rules, she is eligible to be reappointed as chair. Unfortunately, we did have a member resign, so we will need a new vice chair. So we will take nominations from the floor, and any other questions, Mr. Task will be happy to respond to.
Okay. So do we have anyone who wants to move to nominate a chair?
Yes. Member Gary Baker, again, I move that we reappoint Leanne as our chairman. Our chair, sorry.
Do we have a second?
Second.
Okay.
Okay, second, but who is running for vice chair? Do I say my name? I don't know, I'm like new to this whole thing.
I'm sure we can move to nominate you. We'll put this one to a vote.
Oh, to
Since he-
nominate me?
Or
So what the board normally does is we according to parliamentary procedure, we try to do one vote or one motion on the floor that's acknowledged and then vote on that. So right now the motion is for a chair. So if you would like to nominate someone else, then it would need to be seconded. But right now we've got a nomination for Ms. Grayston and a second. Then after, if there's action on that motion, then we would take nominations for vice chair. So if you wanted to nominate yourself, you could.
that you can. So for the motion, is it okay if I call the vote?
Yes.
Yes, okay. So for me to continue as the role of chair, all in favor say aye.
Aye.
Did we have any nays? And I abstain?
No, you have to vote.
Oh, I have to vote as well?
Yeah.
Okay, well then aye. So it's unanimous. Okay, so motion carries. Do we have a nomination for vice chair?
I guess I put my foot in my mouth, so I'll stay there.
Perfect. And you're Ms. Coley?
Leslie Coley, yes.
Okay. So we have a motion for Ms. Coley to act as vice chair for the upcoming year. Does anyone second the motion?
I'll second it.
Okay. Let's vote on it. All in favor say aye.
Aye.
Aye. Anyone disapprove? That was unanimous. So motion carries for Ms. Coley to serve as vice chair. Next item on the agenda, and I thought I was going to get out of this role because I was hoping y'all would elect someone new. I'm just kidding. Next item is to review the nuisance abatement ordinance and sunshine law, and I'm assuming Attorney Trask is going to do that for us?
Yes, I'm going to be doing that. So just a reminder, everyone, I am the board's attorney. Mr. Smith is the city attorney. I'm here to represent your interest, to make sure that due process is given, and make sure that your rules are followed, and make sure the statute and the code is followed. So if you ever have any questions for the two new board members, I'm going to give you my business card after the meeting, and so you can call me directly if you have any questions. But the purpose of today is since we do have some new board members, to briefly go over the ordinance that appointed this board or created this board, briefly go over the sunshine law, and I briefly want to go over some other things that I handed out today. So I'm going to start out with the ordinance that created this nuisance abatement board, and I'm going to go through the major topics. If you have questions along the way, please don't hesitate to ask. So first of all, this Nuisance Abatement Board was created in 2015 by city ordinance. It is now in the city code book and has been for the past 6 years. It's created pursuant to a Florida statute that allows the city to create a Nuisance Abatement Board. The board consists of 7 board members. The ordinance that I'm referring to is Ordinance 8692-15 that was adopted March 19th, 2015. So in addition to you being here, you also have certain powers and some obligations. First of all, you have the ability to adopt rules for administration. This board already has some rules in place, and in fact, they were modified the last meeting a little bit. So you always have the right to address your own rules or create your own rules so long as they comply with state statute and the code. The board has the power to subpoena respondents. Those are the people that are being charged with having nuisance properties. You have the power to subpoena witnesses to hearings beside the respondents. You have the power to subpoena evidence and records to the meeting if you want to do that. The purpose of the board is basically to hear a complaint that's been filed by the city. The city attorney is normally the one that produces that complaint and also prosecutes the complaint here before the board. The complaint has to show that a certain activity has occurred for it to get to the Nuisance Abatement Board. I just want to go through those activities. I won't go in detail about the rest of the things in your ordinance, but for them to be here, they have to, on one occasion, the property has to be used for unlawful possession of a controlled substance where such possession constitutes a felony, and that it has been previously used on one or more occasion, all within a 6-month period as a site for unlawful sale and delivery, manufacture, and cultivation of a controlled substance. The second way is on more than 2 occasions within a 6-month period, the property is used as a site in violation of 796.07, which is the Florida statute dealing with prostitution and prostitution-related activities. The third way is on 2 or more occasions within a 6-month period, the site's being used for unlawful sale, delivery, manufacture, and cultivation of a controlled substance. The next is by criminal gang activity, as it's defined in the statute. And the next is 1 or 2 occasions in a 6-month period of time the site is used in violation of the statute dealing with stolen property. And lastly, on more than 2 occasions within a 6-month period of time, any pain management clinic, as described in Statute 458-3265, is used in violation of the listed statutes relating to assault and battery, burglary, dealing in theft, robbery, and unlawful distribution of controlled substances. So those are the types of things that will bring the complaint before the board for review. The ordinance provides the items that need to be included in the formal complaint that's prepared by the city's attorney and is brought to you for consideration. There's a long list of those items. Once that complaint is filed and it's before you, you'll have to conduct a public hearing on the complaint and receive evidence pertaining to the conduct described in the complaint. The owner of the property that's been cited and each respondent shall have the opportunity to appear before the board in person or through legal counsel to offer evidence in defense of or in mitigation against the complaint that's been filed. The city attorney shall present evidence before the board on behalf of the city. Some of those items you're going to see as confidential informants, sometimes on undercover police officers. Well, you'll hear other voices. You will not actually see them in person. They'll be attending by video. Everyone has the opportunity to present evidence and argument on all the issues involved and conduct cross-examination and submit rebuttal evidence and be represented by an attorney if they want it. At the conclusion of the hearing and after consideration of all the evidence presented at the hearing, the board is going to issue findings of fact based upon evidence presented and made a part of the record, and that a public nuisance does or does not exist, or that an unlawful public nuisance does exist. And in addition to that finding, it's a written finding that is actually prepared by the city attorney's office and sometimes with my assistant based upon the direction given to me by this board. Some of the things that this board has the ability to do is to impose a fine of up to $250 a day for each day that the conduct occurred. which was the finding of public nuisance. If it's a recurring violation, it's happened more than once, up to a $500 a day fine. This board can also award reasonable costs associated with the investigation and the hearing on the public nuisance, including attorney's fees, investigative costs, and costs of recording of the order. There is one caveat: the total fine imposed by this board is limited to $15,000. That does not include the attorney's fees and the costs. This board retains jurisdiction under the order for a 1-year period of time after the order is entered, and it stays valid for that 1 year, and then it will expire. The fines and the costs that were awarded will not expire; those will still be required to be paid. When the order is entered and signed by the chair, it will be eventually recorded in the public records, and it will become a lien against the property in which the nuisance existed. Just a reminder also that there is no lien created on property that is homesteaded property under Section 4, Article 10 of the Florida Constitution, so people don't have to worry about losing their home to foreclosure by way of an order entered by this Nuisance Abatement Board if there's their homestead property. With that in mind, I think that I've covered generally what I wanted to, and a big overview of the ordinance that gives you your powers here on the Nuisance Abatement Board. Does anyone have any questions before I move on to some of the other topics I wanted to cover? No? Okay, so I had passed out a packet of information in front of you. This is printed copies of some state statutes I wanted you to be aware of. Those board members that are already on the board are not new. I've already heard this spiel that I've given, and I'm going to give it, frankly, as a refresher and also as a heads up to the new board members so that you understand that you are governed by the Sunshine Law. And I want to talk to you a little bit about what that means. So the first statute we're going to refer to is the Sunshine Law. It's the one that's got the number at the top, 286.011. And then it says public meetings and records, public inspection, criminal and civil penalties. That's the statute I'm talking about now, the Sunshine Law. And some background for you, just so that you know, back in 1968 when the Florida Constitution was revised, there was a provision that was added in the Florida Constitution that dealt with open government. And that open government provision included that government activities would be done in the sunshine or in the public, and also there was a provision added addressing public records and the availability of public records for anyone that wanted them if they were not otherwise exempt or confidential. So let's talk about the Sunshine Law first. So the Sunshine Law applies to a gathering of 2 or more members of the same board. So that means any 2 of you that are sitting up there, you cannot be having a conversation or discuss anything outside of this meeting that has to do with a matter that will eventually come before this board for action. You can talk about anything else. You can talk about the weather. You can talk about the lightning, the bolts, the rays, anything that you want. Just don't talk about items that are going to come before you for board action here. You cannot enter into those discussions by way of face-to-face conversations, emails, texts, letters, telephone calls, Facebook, blogs, anything that you can think of. There should be no communication back and forth between any 2 of you about any item that will eventually come back before the board. So it's very, very broad, and it's very, very important that it's complied with. I'm going to talk to you a little bit about the consequences of it in just a few minutes. But I also wanted you to know that you cannot use a liaison or a person between you and another board member to gather or transmit information. So Mr. Baker, for example, cannot be contacting the city clerk and asking her to poll all the rest of the board members as to what their thoughts on a particular matter and get back to him, and so he has that information. Using the city clerk as a liaison is an improper use, and it would be a violation of the Sunshine Law. So obviously the city clerk knows that, and the city attorney and I know that. That won't happen, but I'm just telling you, it's an easy example. So just remember that it's not only direct conversations by way of phone call, direct communication, email, text, blog, Facebook, whatever, but it's also that indirect transmittal of information that will eventually come back before the board for action. There are 3 things that are required under this statute, and they're all included in the first 2 paragraphs of that statute that I've given you that create the Sunshine Law. Those three things are that every meeting has to be open to the public, and you can see that this meeting is open to the public. The door is open. Anybody can come in and participate in this meeting so long as they're recognized by the chair. The second factor is that reasonable notice of this meeting needs to be given. That's the city clerk or the city attorney's office will create the notice for this meeting and make sure that the public knows that the meeting is actually taking place. Reasonable notice means that it's given at a period of time, a reasonable period of time before the meeting actually occurs. That's different based upon the circumstances, but I think that you can see from the city clerk, she got it out, a week or so in advance of the actual meeting. The last thing is that minutes of the meeting have to be taken. That's the third requirement under the Sunshine Law, and you've already acted upon the adoption of the minutes of the last meeting. You'll be doing that again month after month after month. But those are the three requirements of the Sunshine Law. So what happens if you violate it? Well, if there's an unintentional violation, it's a $500 fine. If it's a knowing violation, it's a $500 fine and 60 days in jail. So it's very, very important that you make sure that you don't violate the Sunshine Law or put the other members in a position where they have violated it because of one of your actions, making a phone call or putting the other member in jeopardy. So, any questions about the Sunshine Law before we move on? No. And by the way, after this meeting, if you have questions, obviously give me a call. I'll be happy to answer them. In addition to that statute, I've handed out this little guide to the Sunshine Amendment and Code of Ethics for public officials and employees. This is just a little brochure that we use. It has some information, a little bit of information about the Sunshine Law, prohibited activities and conduct. I'm not going to get into that today. And other forms that could be required to be filled out and filed with the state. If you have questions about this brochure, once you've reviewed it, let me know. But I try to hand this out to any board that I'm representing, just so that you have it. And even though it was not mentioned on your agenda today, I want to briefly talk to you about the Public Records Law. I've provided to you 2 additional statutes in copy, printed out form. The Public Records Law that I mentioned to you that was included in the Florida Constitution and later included in the state statutes, just like the Sunshine Law was, is shown in the statute that's labeled 119.07 at the very top of the page. Inspection and copying of records, photographing public records, fees, and exemptions. This is the statute that basically says that you as a board member may have the possibility of obtaining public records that you have to retain or otherwise make available to the public if they're requested. So for example, if someone wrote you an email or sent you a letter that didn't go through the city clerk's office or another city staff member, you would be basically in possession and a custodian of that public record. And so you just need to make sure that if you do not want to retain it, you can bring it to the city clerk and she will retain it for you. Or you will need to retain it for the retention period required under the state statute. And again, the timing of each one of those types of documents, how long they're to be kept by you, is set also by a regulation. And since you're not going to know what that is, my suggestion is you give it to the city clerk and you don't have to worry about it. So this state statute then says that if someone requests a public record that you have in your possession, and that could be anything from an email, a letter, a photograph, a video recording, a tape recording, anything that would transmit information that you received as a result of you being on this board, then that would be considered a public record. And so just understand that you may be asked for that at some time. And so to make sure that you don't destroy it without asking the city clerk first. You can see that in the public records statute that I gave you, it's only 4 pages long, pages 1 of 4. And then I handed you what the exemptions are. That's under 119.071. That's the thick packet I gave you. The reason I gave that to you is to show you that even though there's only 4 pages in the public records law, there's 21 pages of exemptions. And so obviously we know that you're not going to memorize these. We don't try to memorize them, but I want to let you know that just because something is considered a public record, it may not otherwise be available to the public for review because it is exempt or it is confidential. That's one of the jobs that the city clerk and the city attorney handle, is if you get a request for a public record, they're going to make the determination of whether or not it's exempt or confidential, and so you would want to be asking them if someone asked you for a public record in your possession. The things that are exempt are things that you're probably already aware of: medical records, social security numbers, active criminal investigations, the addresses of certain protected individuals, such as your city clerk, the human resources officer, city manager, city attorney, code enforcement, police officers, firefighters. A lot of the information relating to where they live, where their kids go to school, and that type of thing is protected. And so that's what this statute is all about. And again, don't try to memorize any of it. I just want to let you know that there are some exemptions to public records requests that come about. So, I think that's all that I wanted to briefly cover today. I've taken about 25 minutes of your time. Is Matt or Rosemary, anything else that you want me to cover or you want to talk about?
No, I think in terms of this topic, I think you've covered. I just would like to stress in terms of if you receive any communication, city policy is that you do forward it to me just so that we capture it on our server with the understanding, like Mr. Trask said, and explain that if you do not forward it to me, then if I receive a public records request, then you are obligated to comply with the request.
Yes.
Can you give me an example of, okay, first, why would I be getting a public record and sent to my email, and what, like an example of something that I would receive that I need to?
So let's say, and this happens, I'm going to give real life example. We do have individuals in the community, residents, who just, let's say they are aware of a topic that they think is coming before you, whether they saw the agenda or it's something that they're very passionate about and they think it falls within the auspice of this board's authority. So what they will do, they will ask me, I would like a copy of everybody's emails, the board members. So unless I am given an exemption where your personal information is not available should not be available to the public, I provide that information. Now that individual has decided I'm going to email each and every single member an email asking them to discuss this topic, whatever the case may be. So at that point, that when you receive it, that becomes a public record. And so just keep in mind, if you do receive that and you see other board members carbon copied on those emails, you are not to communicate with other board members, because if the item can come before the board, it would be a violation of public record. So let's say you didn't tell me, nobody said anything because nobody thought about it. Then that individual or somebody else knows of that correspondence, and they'll ask me, well, I want all the emails to and from, and they list all the board members' names. And that's when I go to you and say, okay, I need emails that you may have received regarding whatever topic. If they give me a topic from this time to this time. And so that's where it becomes a public record.
Thank you so much for the clarification.
No problem.
Matt, is there anything that I missed that you may want to cover?
No, I think you covered it. I am going to speak to the board in the next item, 4.3.
Okay. Any other questions from the board then? All right, thanks for your time. I appreciate it.
Thank you. So we'll move on to you, Matt, with the staff update on the nuisance abatement process.
Sure. Afternoon, board. My name is Matt Smith. I'm an assistant city attorney. I'm assigned to the police department. And as Mr. Trask explained, I would represent the city in any prosecutions that would be brought before you. Real briefly, I just wanted to explain the beginning part of the nuisance abatement process, because that's a part that you don't see. What you see is when the property is so bad that we actually have to file a complaint. So the process actually begins when law enforcement identifies a problem property. And it's going to be one of the activities that Mr. Trask identified, such as drugs. It's usually drugs, could be prostitution, could be gang activity. Then the police department has to build the cases. They have to actually send out either uniformed officers or undercover officers, and they will build at least 3 cases. Once they do that, they send that to my office, and I review the cases. And if I determine that the cases fit within the statute and it fits within the ordinance, then I prepare a letter. And the letter is sent out by the chief, but I prepare it, and it basically notifies the property owner that, hey, this activity is occurring on your property, and if it continues, then you could, well, it lists all the powers that the board has. It could be fined, their business could be closed, all these things. And then they're asked, really ordered, to reach out to the local lieutenant, for their property, for the appropriate district within 10 days. And the purpose of that is so that there can be an interactive process between the police department and the business owner or the property owner. And the intent is to mitigate what's going on at the property. And 9 times out of 10, it works. And to let you know, since the last meeting, which was March, so over a year ago, there's been 8 letters sent out. And as you can see, there's no cases before you today. So all of those properties have been resolved. And it takes a couple months of working back and forth. One of the ones I can recall was it was a hotel, and they had drug activity. And so some of the suggestions that the lieutenant made were increase the lighting, get a camera system, or if you have a camera system that's broken, you got to get it fixed. Make sure you're keeping the recordings long enough. I think this particular property wasn't requiring written leases, and so they were doing that. And when you do that, you've got the license, you've got more information on the person. It's not just a verbal agreement. So these are some examples of mitigation steps that the police department would go through with the owner. So only in the event if that process fails, meaning either the property owner or the business owner is in on the illicit activity, or they're unable or unwilling to make the steps and make the corrections that they need to take to satisfy the police department, that's when it goes to you guys. So that's the process. Any questions?
I'm interested to know, because I think we've had 3 judgments where we actually did fine people. Do you keep track of whether those properties do improve and the fines are paid?
Certainly, because the last one that I remember doing, there were a lot of conditions that were in the order, and the board retains jurisdiction for a year.
Right.
Which means that order is enforceable for a year. I can bring it back before the board and say, you ordered them to do X, Y, and Z, and they did X and Y, but they forgot Z, so we're going to impose an additional fine or make additional orders. So certainly.
So fair enough. So we have made a difference then in
Oh,
the
yeah.
ones that we were able to decide on. Good to know.
You had mentioned that hotel example, and one of the suggestions was to get leases. So this hotel was functioning in an apartment status?
Yeah, it was, if I recall, it was a very short term. I'm
Okay.
sorry, it was kind of a flop house. It was kind of longer term. It wasn't your typical hotel. It was, people were staying there they were living there basically.
Okay.
But it was just month to month. It was verbal, and it just was the type of clientele that was attractive to was part of the problem, right? So these are people that wouldn't pass a background check, or they wouldn't want to present their identification, and they wouldn't want to sign a lease, and so
Gotcha.
there's a market for that.
Okay. Thank you.
Not anymore at that property.
Any other questions for Mr. Smith? No? Okay. Just before we adjourn, I do want to thank both of you for volunteering your time. I think we're all pretty appreciative of that, so welcome.
Oh, thank you.
We appreciate it. Is there any other business? Nothing else on the agenda?
I'd like to
Okay.
mention that the financial report, at least mine, is due July 1. And so everyone should pay attention to that, because that can sneak up on you too.
Absolutely.
Yeah, so that should, if you have not received it, let me know. You should have received it. For those who just recently appointed, you may not have received it. Just drop me a quick email if you didn't. Now, that does not come from my office, but I do report to you as members to the state, and the state division is the one who sends it out through the supervisor of elections. So you actually file it. You don't send it to me. You file it directly with them, and there are instructions. But that is, thank you so much, Member Baker, because it does come across, and then sometimes we just throw it in a pile and we forget about it, and then you don't want me calling you after I've received calls from the state asking, before the fine set in, because it can be pretty hefty after a certain date. We're talking 500 plus days, yeah, so.
I received mine and put it in the mail, $25.
I'm lucky, I have one for my job as well, so I get duly reminded.
And I understand, because I get one too. So.
Yeah. No other business from the members?
Move we adjourn.
Okay, yes, I'm gonna adjourn this meeting as of 3:35 PM. Thanks, everybody, for your time.
Thank
you.
you.